As you're aware, the case is fixed for tomorrow, the 20th of March, for conclusive and concluding submissions to be made. It is fixed for hearing. While we are awaiting that hearing date and preparing our submissions as ordered by the judge, we received an application filed Friday by the GTU through its lawyer, Darren Wade. In that application, Mr. Wade seeks a number of remedies. We felt that the application is incurably bad in law. We felt that the application is hopeless, it is frivolous, it is an abuse of the process of the court, and it will unduly delay the hearing and determination of the case, which is fixed to be heard and determined on the 20th of March. As a result, we filed an application to strike out the application filed by Darren Wade, as we are entitled to do under the rules of court. So that application of ours came up at the same time when Mr. Wade's application came up for hearing, that is today. So the judge had both applications. The court quickly realized that we were right and that the application filed by Wade was hopeless, was misconceived, and utterly wrong. The court invited Wade to explain why he filed what he filed, seeking to expand the case. And one can expand a case that is ongoing, but you have to follow the proper procedure. You have to apply for an amendment and amend your case to accommodate the new reliefs that you are seeking. That's the first thing. That was not done. Secondly, you have to ask the court for reliefs that the court can grant. You can't ask the court to make final reliefs in an interlocutory application. And there are many other technical deficiencies that plagued Mr. Wade's application, all of which, to the court's credit, was pointed out by the court to Mr. Wade. Then, of course, the court invited us to speak. And I pointed out, well, I have an application to strike Mr. Wade's application from the proceedings, as it's an abuse of the process of the court. In the end, after much exchange, and the court got Mr. Wade to admit that his application was hopelessly wrong, misconceived, and incurably bad, and the court granted him leave to withdraw it. The court was kind enough not to order costs against him, and we did not seek costs because we don't want to detain the substantive matter. However, at the very end of the proceedings, the judge raised an issue about inconsistency of the different inconsistencies of facts put forward by both sides, because the teachers' union has a particular narrative and the government has a narrative. So, in an effort to reconcile the narrative, the judge ordered us to produce some documents showing the engagements with the government, which the government had with the teachers over the past couple of years. So we have undertaken to produce those documents, and the judge asked us to make Saddam Hussein available for cross-examination, if possible, if necessary, sorry. So Mr. Hussein will be there, and we have undertaken to produce the documents which the judge is asking for. But in my view, those documents do not advance the case. This is not a case where the factual collision, whatever they are, will impact upon the law. The law in the case is very simple. If you do not work, you do not get paid. And the government is free not to offer voluntary service of collecting union dues from workers' salary and passing it on to a union. The government, yes, was doing that service, but there is no compulsion or obligation in law for the government to continue to do that. I am doing you a favor. If I don't want to continue doing it, I must be able to stop. No court ought to compel me to continue to do a favor for you, especially since you're asking the government to take teacher's salary or monies from teacher's salary and give to you, and you have not filed any accounting record as required by the law with the Registrar of Trade Unions. You have not filed your assets and liabilities account. You have not filed your income statement. You have not filed your financial annual returns. Your documents have not been audited, either by the Auditor General or any other auditor for 30 years. In terms of and the law requires these things to be done. The Trade Union Act, for example, under Section 35, makes it a criminal offense for the non-filing of annual returns with the Registrar of Companies. An offense that carries a summary conviction of every officer of the union. So that union currently, for non-compliance with that particular legal requirement, all the members of that union, all the officers of the union, are potential criminals, having committed a summary offense under the law. And they have done it for 20 successive years. And you want a government to continue to deduct monies from people's salary and give it to you? On what basis? Governments have a duty under the law to ensure that monies that fall within its responsibility is properly accounted for, properly spent, and transparently accounted for. I am giving a rogue union this money that is refusing to even do the basic in terms of accountability and transparency to its own members, and you want me to continue to do that? So those are the legal issues. And this country seems to have a gross misunderstanding of what collective bargaining is. Somehow out there, in particular in the media, it is believed that collective bargaining is some magical formula and manifests itself in some strict and rigid way, and that it is some science. Collective bargaining simply means bargaining on the part of a collective in an industrial climate. Normally you have a union on one side and you have the employer on the other side. And the union is bargaining on behalf of the workers. The government is bargaining on behalf of the employer. And that is what collective bargaining is. And what they are bargaining about? What will improve the workplace, the work environment, and the welfare of the worker. It's as simple as that. So there is this notion out there that, oh Lord, there was no collective bargaining between the teachers' union and the ministry. The union was engaging the ministry for the past, I don't know how many years. What were they doing? It's collective bargaining. They were not discussing their personal businesses when they met and when they are meeting. That is collective bargaining. Now, one side may feel that what should be on the agenda is not being discussed, or what they would like to be placed on the agenda is not placed on the agenda. That's a different thing from saying that there is no collective bargaining. So I hope that in your newscast, you make it clear. So we are going back tomorrow, and hopefully we will conclude the case, and these important areas of law will be settled.
Okay, Minister. Given Justice Samuel Kasoon's decision this afternoon, do you believe that it's a win or at least a step in the right direction for this whole back and forth between the government and the GTU regarding the way that he was able to point out the inaccuracies with the way Darren Wade filed his application and just filing the application in the very least?
The court, as I said, the court was moved by Darren Wade by an application that the court dismissed without even, engaging the other side really. The application was hopeless. Should never have been filed. Where the court may have been in default, it did not order punitive orders for costs. And courts have to start doing that now, because judicial resources are a scarce thing. And, it costs taxpayers money every time a court has to sit. But, I believe we had a good hearing in terms of the a ridiculous application being dismissed. Right?
Okay.
All right.
One more question. Looking at tomorrow's hearing, what are your expectations going into that?
I have done our submissions, and I'm convinced that the law is clear and that we should succeed. I don't think, as I said, that this matter depends upon any great amount of evidence. These are pure legal issues. Whatever is the factual dispute, once you don't work, you can't get paid. Whatever is the factual dispute, whether you are in collective bargaining or you're not in collective bargaining, you didn't do your work, I'm not going to pay you. The very definition of wages is that payment for work done or to be done. And that is how strikes are all over the world. I mean, strikes are not new to Guyana. When Gaisuku strikes, Gaisuku workers strike, why do you think you have to get strike relief and you have to get monies to pay the workers? Because they're not getting paid. They're not getting paid. That's why Coretta MacDonald, when the government said that it will not pay the teachers, she said that they have corporate sponsors. What do you think she meant? She recognized that the government doesn't have to pay, but she will find other monies to pay the workers. That is what she was saying. Recognizing what the law is. At least one sensible thing came out of that.